Hello and welcome everyone. We're excited to have you join Registrar Corps for Unveiling the Clean and Navigate the Clean Beauty Movement with Confidence. I'm Jacqueline Belomo, the Director of Cosmetic Science and Regulatory Affairs here at Registrar, and we are honored to partner with Perkins Coie to unmask the complexities behind the booming clean beauty trends and highlight regulatory and legal pitfalls to avoid. I am pleased to introduce Christine Kruger, Senior Counsel at Perkins Coie, a seasoned litigator with more than 10 years of experience in the consumer products and service industries. She has worked closely with clients on risk management and compliance issues related to cosmetic product safety, labeling, and advertising. Throughout the webinar, feel free to write any questions in the Q&A box, and we'll save some time at the end. But without further ado, Christine, take it away.
Great, thank you so much. I'm very excited to be here today to speak about all things clean beauty. I am a huge fan of the beauty industry, and I love working with my team to defend personal care companies and cosmetics companies in litigation. I'm a litigator at heart, but I also love providing regulatory compliance advice to keep my clients out of the courtroom in the first place. So that's a lot of fun for me. Today, we'll be discussing clean beauty regulations and recent trends in litigation and in the personal care product space. My hope is that you'll take away a few tips about how to be compliant and to avoid litigation. So, what is clean beauty and what makes a personal care product clean? Well, to date, the term clean has been undefined by regulators, and clean beauty is largely unregulated. Consumers associate the term clean beauty with natural, non toxic, organic, and safe, but there's no set of legal or regulatory guidelines governing the use of this term or these terms. And so while there's no universally agreed upon definition of clean beauty, some companies have defined clean products as those that typically avoid parabens, phthalates, synthetic fragrances, formaldehyde, and artificial colors. And the clean beauty movement, as you all know, has absolutely taken off. Some of the reasons for this include first, there's really a growing consumer awareness of potentially harmful contaminants in products due to product testing lately, and the testing methods have become so accurate that they're able to test, even the parts per trillion of certain microcontaminants. There's also an increased focus on overall wellness and self-care and a related desire for more healthier, more natural alternatives. There's also environmental and sustainability concerns. And of course, with the rise of social media and influencer marketing, we're seeing a lot of movement in this space. So nearly 1/3 of the United States beauty market is now labeled clean, and we're expected to see that increase at least by 12% over the next 4 years. And consumers today are really paying close attention to product ingredients, sustainable packaging, ethical sourcing, and the integrity of the company behind a product. So let's look at some of the 2024 top clean beauty trends. The clean beauty landscape is, of course, constantly evolving, and there's new trends emerging all of the time. And in 2024, we're seeing a surge in bio-based ingredients, offering sustainable and potentially more effective alternatives. Of course, the importance of skin microbiome is gaining recognition, leading to the development of microbiome-friendly skincare products. Customization remains a key trend, with consumers seeking personalized solutions for their unique needs. And of course, sustainability is at the forefront, with brands focusing on minimalist packaging, refillable options, and recycling of their products. And finally, the do-it-yourself movement is also taking root in the clean beauty space, with some consumers opting to create their own skincare products using natural ingredients. Vogue actually recently put out an article about rice water for hair treatment, and I know that's been very popular on TikTok, so I hear. So, as brands set new trends and keep up with consumers' demand for clean beauty products, what are the regulators and legislators doing to manage this industry? Well, we've all seen an uptick in ESG regulations and guidance in the United States and in Europe recently, but we're also seeing a great deal of attention from plaintiffs' attorneys with increased litigation brought against clean beauty companies. Litigators love to fulfill these regulatory gaps. As personal care companies lean in on the clean beauty movement, it's important to take steps to mitigate the risks of both regulatory enforcement and private litigation. So, by way of background, I'll run through ESG and how regulators and plaintiffs' attorneys are viewing ESG programming. So, ESG is the framework that helps stakeholders understand how an organization is managing risks and opportunities related to environmental, social, and governance criteria, the ESG factors. And in the first factor for environmental, stakeholders review how a personal care company acts towards the welfare of the planet and its impact on the environment. So, what are companies' products' ingredients? How are the ingredients sourced? And how do they impact our planet? Is the product packaging recyclable? The E in ESG is where clean beauty traditionally falls, but note that clean beauty consumers also look at social and governance factors as well. Social factors include how a company treats its employees, its customers, its suppliers, and communities. Factors include diversity, inclusion, and recruitment practices. In other words, how is this company taking care of its people? How is the product helping me or hurting me? Governance factors review how a company is run. Factors include risk management, compliance, ethical business practices, and accounting integrity and transparency. So, does your company have ethical business practices? Is there greenwashing going on? Does the company put profits over the planet? So, now that we've covered a little bit of background on clean beauty, let's talk about some regulatory updates. So, how are cosmetics regulated and who regulates clean beauty? Cosmetics and personal care products fall under the FDA's regulatory domain, of course, and the laws listed here provide the FDA and the FTC with authority to regulate cosmetics. We have the 1938 Federal Food, Drug, and Cosmetic Act, which is a set of laws passed by Congress way back in 1938, which gave the FDA authority to oversee cosmetics along with food, drugs, and medical devices. And of course, the FDA finds a cosmetic product, excluding pure soap, as in those intended to be applied to the human body for cleansing, beautifying, promoting attractiveness, or altering the appearance. We also have the 1960 color additive amendments to the Act, which defined color additive and require that only color additives except coal tar hair dyes listed as suitable and safe for a given use could be used in cosmetics. And then the Fair Packaging and Labeling Act directs the FTC and the FDA to issue regulations requiring that all consumer commodities be labeled to disclose net contents, the identity of the commodity, and the name and place of the business of the product's manufacturer, packer, or distributor. And what about MOGRA? We all know that MOGRA is the most significant expansion of the FDA's authority to regulate cosmetics since the FD&C Act was passed in 1938. But does MOGRA regulate clean beauty? In fact, it has moved the ball forward in the FDA's regulation of certain microcontaminants in cosmetic products. Under MOGRA, cosmetic companies are required to ensure and maintain records supporting that there is adequate substantiation of safety of all cosmetics sold into the United States. And also under MOGRA, the FDA will promulgate regulations for good manufacturing practices with a final rule that will come into place by December 29th, 2025. The FDA is also required to promulgate proposed regulations to establish and require standardized testing methods for detecting and identifying asbestos in talc-containing cosmetics. And as of April 5th, 2024, per the FDA's website, this is still in the works. So under MOCRA, the FDA also needs to assess the use of PFAS in cosmetics products and the scientific evidence regarding the safety of their use in cosmetics products, including any risks associated with such use. So as of January 2024, the FDA published information regarding PFAS in cosmetics products on its website, including a list of ingredients that consumers should be aware of when purchasing cosmetics. And when we think of clean beauty, of course, we consider whether a product has been tested on animals. We've seen a lot of litigation in this space recently, which we'll discuss a little bit later. But under MOCRA, Congress states that it has the sense that animal testing should not be used for the purpose of safety testing on cosmetic products and should be phased out with the exception of appropriate allowances. But note that this is not binding law, so there's no federal prohibition on animal testing in cosmetics products in the United States at the federal level. So let's talk about the FDA's ingredient ban. And of course, we've all heard that the EU has banned close to 1,400 ingredients in cosmetics, whereas the FDA has banned 11. But it is against the law for a cosmetic to contain any ingredient that makes the product harmful when consumers use it according to the directions on the label or in the customary or expected way in the United States. This is true whether or not there is a regulation that specifically prohibits or restricts the use of the ingredient in the cosmetics. So although it is against the law to use any ingredient that makes a cosmetic harmful when used as intended, FDA has regulations that specifically prohibit or restrict the use of these ingredients that you see on the screen here in cosmetics. And while it is often noted that the ban on ingredients in Europe is much more robust than the list of ingredients banned in the United States, this is due to the different ways that the two organizations approach regulation. For example, sunscreens are regulated as cosmetics in the EU, but as drugs in the United States. And in the United States, manufacturers are responsible for ensuring that their products are safe. So given this perceived lack of regulatory oversight at the federal level, states have come in and are filling that federal void and passing ingredient bans in cosmetics at the state level. So there's a growing trend in the United States whereby individual states are pursuing state level legislation regarding the use of certain ingredients in cosmetic products. It's becoming a full-time job to keep up with these state regulations. And ideally, the federal government would step in and implement nationwide regulations for products and ingredient bans. But for now, it's important for cosmetic companies to be aware of and comply with the following state regulations that are listed. Of course, in California, we have the Toxic Free Cosmetic Act, which takes effect in January 1st, 2025. And then other ingredients intentionally added in cosmetics. I think there's now approximately 50 ingredients on a list that California is banning. And those bans take place starting January 1st, 2025, with the second ban taking place January 1st, 2027. Washington State, never to be outdone by California, also enacted its own Toxic Free Cosmetic Act, setting stringent standards for intentionally added cosmetics, which also begins January 1st, 2025. So you'll want to be aware of that deadline as well in Washington State. Notably, this act prohibits intentionally added lead in the amount of 1 part per million or above. Oregon has its own Toxic Free Cosmetic Act, which goes into effect on January 1st, 2027. And New York has banned cosmetics containing mercury. Minnesota also has jumped on the bandwagon and has laws in place regarding the sale of products containing intentionally added PFAS and restrictions on lead and cadmium. So if your company sells its products into these states, it's important to make sure that you're in compliance with these state regulations as they come into place in January. So we all know that the FDA oversees the safety of cosmetic products, and it also has primary responsibility for claims that appear in labeling, including the packaging, product inserts, and other promotional materials available at the point of sale. The FTC, on the other hand, has responsibility for claims in all forms of advertising. So the FTC and the FDA share jurisdiction over the marketing of personal care products and cosmetics. Under the FTC, advertising must be truthful and non-deceptive. Advertisers must have evidence to back up their claims, and advertisements cannot be unfair. So what makes an advertisement deceptive? According to the FTC's deception policy statement, an ad is deceptive if it contains a statement or omits information that is likely to mislead consumers acting reasonably under the circumstances and is material. In other words, is important to a consumer's decision to buy or purchase the product. And what makes an advertisement unfair? According to the Federal Trade Commission Act and the FTC's unfairness policy statement, an ad or business practice is unfair if it causes or is likely to cause substantial consumer injury which a consumer could not reasonably avoid and is not outweighed by the benefit to the consumer. So under the FTC's laws, advertisers must have a reasonable basis for any product claims before distributing an ad. And any health-related claims, which most clean beauty products make, must conform to the competent and reliable scientific standard, which requires scientific research supporting a product claim can be sufficient in quality and quantity based on standards generally accepted in the relevant scientific fields. So what is the FTC doing about clean beauty specifically? Well, the FTC is all about avoiding consumer deception. And the FTC put out green guides, which were first issued in 1992, that provide guidance regarding the general principles that apply to all environmental marketing claims, how consumers are likely to interpret particular claims, and how marketers can substantiate these claims. Finally, how marketers can qualify their claims to avoid deceiving consumers. The green guides specifically provide guidance on how companies should use certain green claims, including general environmental benefits, non-toxic claims, free of claims, and ozone safe or environmentally friendly claims. By way of example, the green guides state that marketers should not make broad, unqualified, general environmental benefit claims like clean, green, or eco-friendly because these broad claims are difficult to substantiate, if not impossible. So here's a list of defined claims by the FTC's green guides. And while the green guides define free of, non-toxic, and ozone safe friendly, the guides do not define organic, sustainable, natural, or clean. So the green guides were revised in 1996, 1998, and 2012. It is about time for an update. We all know that the FTC announced in December 2022 that it was seeking public comment with respect to proposed revisions and updates to the green guides. And specific claims for which the FTC is looking to update include carbon offsets and climate change, including renewable energy claims, the term recyclable, the term recycled content, and how to substantiate such claims, And also, the FTC sought comments on the need for additional guidance regarding claims such as ozone friendly, organic, and sustainable, among others. And it's important to note that while the green guides have no force of law, to the extent that the FTC provides additional guidance for claims such as organic and sustainable, legal compliance with those guides will strengthen defenses in lawsuits challenging these claims. So we're all looking forward to those updated green guides. And while the period for public comment on the proposed revisions and updates has closed, we are very much impatiently waiting to see what the FTC does. So in the meantime, what should you take away from these regulatory updates? Personal care companies should review the existing green guides, the regulatory guidance, and other legally binding requirements, and confirm that your company's marketing, labeling, and statements made on products, in social media, in sustainability reports, in SEC filings, and other public-facing materials follow the regulations and guidance. It's important to review the areas of focus in the FTC's request for comments, including organic and sustainable, and determine whether there are any potential gaps or issues existing relating to your clean claims, including the ability to substantiate them. And it's important to address any gaps right away. Be specific in making green or clean claims and avoid broad statements that are not substantiated by objective scientific evidence. It's important to collect and maintain your company's backup for green or clean claims. This includes keeping records and having good record keeping regarding any claims that your companies have made. And when making such claims, consider disclosing supporting evidence, especially in areas known to be of heightened concern to consumers and regulators. So I want to run through examples of why this is so important. We can't talk about clean beauty without talking about clean at Sephora, of course. And so the Lindsay Finster v. Sephora case was filed by a widely known plaintiff attorney out of New York, Spencer Sheehan. I hope you're not familiar with him, but if you are, he's very notorious in the plaintiff's bar and in the defense bar, frankly. This case was filed in the Northern District of New York, and in this case, the plaintiff alleged that Sephora's Clean at Sephora program was misleading because a significant percentage of products in the Clean at Sephora program contain ingredients inconsistent with how consumers understand the term clean. Plaintiff points to several ingredients in the complaint, including potassium sorbate and xanthan gum, as ingredients that make any clean designation false or misleading. Plaintiff argued that consumers are harmed by the clean representations because they pay a price premium for these products. And plaintiff filed causes of action for violations of state consumer fraud laws, for breaches of express and implied warranties, for fraud, and for unjust enrichment. And to be honest, the complaint was a little bit thrown together. Spencer Sheehan has a reputation for just filing complaint after complaint after complaint and seeing what sticks. Sephora asked the court to dismiss the complaint because it did not market its Clean at Sephora cosmetics under the guise that the products are all natural or free of any potential harmful ingredients. In fact, Sephora states exactly what qualifies a product for its program. It says formulated without parabens, sulfates SLS and SLES, phthalates, mineral oils, formaldehyde, and more. The court noted that the plaintiff failed to identify a false statement in Sephora's advertising of its clean program. The court dismissed this complaint without prejudice and permitted the plaintiff to file an amended complaint on or before March 29th, 2024, which plaintiff failed to do so. And so the court just entered judgment on April 2nd. And this was the right decision by the court. And it taught us that if you're going to make a claim that could be viewed as vague, such as clean, clearly define what that claim means, and ideally on the front of the packaging. And by the way, if you make that claim and define what it means, you still may get sued. There's also a similar case pending against Target regarding its clean program, pending in the District of Minnesota. And in this case, there's a motion to dismiss pending. The defense counsel in the Target case recently filed a letter providing the court with notice formally of the Sephora decision. So we'll see how the Target case pans out, but we're all hoping that it has a similar outcome in that case as well. I want to talk about some other cases too that kind of follow these litigation trends, and note that these cases can be highly judge dependent. We're seeing a lot of litigation trends involving natural, nature, plant-based, and botanical claims. Similar to the clean beauty litigation trend, these claims are also trending. And so it's important to define, again, what you mean by these terms. These cases have, like I said, widely different outcomes depending on the specific wording of the claim, the product line name, and frankly, what the judge ate for lunch that day, it seems. For example, in the Kimberly Clark case involving Huggies Natural Care baby wipes, which has packaging containing the claims plant-based and natural care, in this case, the plaintiff alleged that these representations mislead reasonable consumers who believe that the products are only composed of natural ingredients that come from plants and were not subject to chemical modification or processing. And in this case, the court found that plant-based reasonably means mostly derived from plants, which is what these products are. So in this case, the court dismissed the lawsuit. In the Maisel case against SC Johnson & Son involving eCover brand cleaning products, this case plaintiff challenged claims such as plant-based ingredients and get nature on your side, arguing again that the products contained synthetic, non-natural, and highly processed ingredients. Here in the Northern District of California, the court found that it is plausible that a reasonable consumer could be deceived into thinking the products only contain ingredients that come from plants or from plants and minerals. And this court denied the defendant's motion to dismiss. So it's a case that we can contrast with the first case. And of course, in the famous McGinty case involving Pantene's Natural Fusion line, the Ninth Circuit Appellate Court found that while nature fusion is ambiguous, consumers can look to the ingredients on the back panel to clarify the meaning. So in this case, the court dismissed the claims. And you can see how these cases can widely vary on outcome based on where they're filed, what the claims were made. And so it's so important to make sure that you're explaining exactly what you mean when you say clean or have a phrase such as nature fusion or get nature on your side. Next up in litigation trends, we're seeing a lot of reef-friendly claims on sunscreens being targeted. And I want to distinguish two different rulings that were brought against two different defendants, but with the same end result after an appeal. So in the first complaint filed against Strivectin Operating Company, the plaintiffs alleged that the term reef safe was misleading when the fine print does not address for ingredients that allegedly endanger reefs. And in this case, in denying the defendant's motion to dismiss, Judge Chabria in the Northern District of California held that plaintiff had adequately alleged that reef safe is a deceptive representation under California's consumer protection laws. And the order notes that the complaint sufficiently alleges that the defendant promises that its sunscreen is reef safe, when in fact it contains chemicals that actively harm coral reefs and the marine life that rely on them for survival. So in this case, the court found that the complaint had been adequately alleged and let the case move on past the motion to dismiss phase. Then in the Richardson v. Edgewell case, this court dismissed the complaint on a motion to dismiss in the district court. It was filed in the Southern District of New York. And the court dismissed the complaint, finding that reef friendly with an asterisk behind it is not misleading. The court found that the asterisk appended to the representation reef friendly asks consumers to read the rest of the label, which clarifies that the product contains no oxybenzone or octinoxate in compliance with Hawaiian law. And this decision in the Richardson case was appealed, and unfortunately the Second Circuit reversed in a non-precedential opinion, holding that the challenged labels could mislead a reasonable consumer into thinking that the products contained no reef-harming ingredients. The opinion further explained that the ingredient list would not provide clarification in this case because a reasonable consumer could not be expected to know the universe of chemicals harmful to coral reefs, such that they could determine whether a sunscreen product was in fact reef-friendly. So these opinions are yet another example of how vague marketing slogans, even coupled with clarifying language on the back of the label, can be deemed deceptive and capable of surviving a motion to dismiss. Some courts are holding that ingredient lists and other clarifying sources of information on the label are not enough to cure an allegedly deceptive representation made on the product itself. So again, these cases are kind of going all over the place, and it's hard to keep track of what exactly a reasonable consumer will find misleading and not. And the courts are still grappling with this themselves, which makes it difficult to comply. So another huge litigation trend that we're seeing is microcontaminants. And of course, we're seeing complaints being filed regarding the alleged presence of benzene in certain sunscreens, antiperspirants, and dry shampoos. There's a lot of action around titanium dioxide, which is allegedly in pressed powders, including eyeshadows, powdered blush. This is also a big issue in California's Prop 65. We've seen a lot of Prop 65 notices of violations served against cosmetic companies regarding titanium dioxide. We're also seeing PFAS in cosmetics, mascara, cream foundations, other gel-based soaps and personal care items such as shampoos and body washes. And you might be wondering why all of a sudden this is becoming such a trend. And really, it's the increased accessibility and affordability of lab testing. The analysis in lab testing is now more accurate, and these tests can truly detect far lower limits, and they're cheaper than you might think. Some of the best labs in the country will do testing for attorneys for around $75 per analysis. So it's easy for plaintiffs to purchase a lot of these items and send them for testing. And if they have any trace amounts of microcontaminants, they can and will file a lawsuit. These up here on the screen are the most common issues that we're seeing and the types of products that are targeted. And something to be aware of is that plaintiffs not only target the content of the product, the supplement and the soap or the eyeshadow, they're also targeting the external packaging. So note that PFAS and phthalates are a big issue in packaging as well. Another trend we're seeing is the cruelty-free and not tested on animals trend. These claims, as we mentioned, animal testing is not prohibited in the United States at the federal level. And these phrases, cruelty-free and not tested on animals, are not restricted by the FDA. But such claims have been the basis for lawsuits against several cosmetic companies that have claimed that their products were cruelty-free when the products were allegedly tested on animals pursuant to law in foreign countries. And companies making such claims are encouraged to assess whether the product as a whole or the company as a whole can make a cruelty-free or no animal testing claim, as well as to inquire with suppliers as to specific ingredients and whether or not they've been tested on animals. There was a lawsuit recently filed against John Paul Mitchell and several others that have come up thereafter against various companies, in which the Paul Mitchell case, the court denied in part the motion to dismiss, finding that the company must face the plaintiff's false advertising claim because it has long marketed its business and its products as cruelty-free. But it once imported its products into China and registered them with the Chinese government at a time when Chinese law required that companies test cosmetic imports on animals as a condition of registration. The court found that by definition, a product that has been animal tested once and a company that has animal tested once can never be cruelty-free again. And so this is a case to watch. And I want to note that we've seen a lot more of these cases come down the pipeline against various companies. So be aware of these lawsuits. There's also certain states that have banned animal testing as well and have legislation pending regarding animal testing. So that's a trend we're seeing in the clean beauty space that it's important to look out for. So it's really important to do a label review of all of your products. I want to note that plaintiffs love ESG statements like Taylor loves Travis right now. Common targets for lawsuits include putting 100%, really anything, such as 100% natural, 100% clean. Be wary of those claims. It's difficult to substantiate them. Free of claims are also being targeted, for example, including no preservatives, things like that. Be wary of making broad-based sustainability claims, including using the term sustainable for a product, and green and clean claims, such as all natural, are being targeted. Recycled content and recyclability claims are also a huge trend right now. And so there's a lot of EPR laws coming into place around the country that it's important to be aware of. And then, of course, in California, we have SB 343, which is about recyclability contents or recyclability advertising on the label. That's a law that it's important to be aware of because it restricts the use of the chasing arrows sign on product labels. Environmentally friendly claims are also targets for lawsuits. And then something like microbiome friendly. It's important to explain what you mean when using these types of claims. So let's talk about best practices for cosmetic companies. The clean beauty market is booming, but navigating this legal landscape, as we've discussed, can be tricky. And here's kind of a breakdown to keep your brand on the straight and narrow. It's so important to be transparent, to list all ingredients, obviously, and avoid vague terms like natural or chemical free. You really need to define the clean beauty standards for consumers and what your clean beauty standards are. Compliance with the FDA regulations, of course. Ensure that your labeling adheres to FTC guidelines for safety and avoid any claims that could be misconstrued. The FTC guidelines as well, including the green guides, it's important to read through those and make sure that you're complying with green guides under the FTC. We're also looking forward to the update of the green guides. Consider certifications, exploring independent certifications from reputable organizations with established clean criteria. This can add credibility to your claims. And then focus on safe and effective ingredients. Highlight the benefits of your chosen ingredients and their effectiveness in achieving desired results. It's important not to make any misleading claims, including avoiding suggesting that your product is a cure-all, is clean, is implying ingredients are inherently bad without scientific backing. Really stay away from those claims that could put your product into the drug category. The use of unregulated terms is also something that you're going to want to steer clear of, including legally undefined terms such as clean or non-toxic. These claims, it's just tough to substantiate them, so it's best to steer clear of them unless you have an appetite for litigation. And overlooking potential allergens, you don't want to do that. Even natural ingredients can cause irritations and reactions, so clearly disclose any potential allergens to avoid liability. Don't skimp on your documentation. Maintain records of ingredient sourcing and safety data sheets for all ingredients used in your products. And complying with MOCRA, of course, as well. So remember that the FTC can penalize deceptive advertising practices, and ensure that your marketing materials align with the reality of your product. It's so important to stay informed about evolving regulations. The legal landscape is shifting so quickly and evolving so fast, so staying updated is crucial. And really, by prioritizing transparency, responsible claims, and safety, your clean beauty brand can build trust and thrive in this competitive market. And consider consulting with your lawyers who are specializing in cosmetics regulations for more in-depth analysis. All right.
Wow, Christine, I mean, that was so much valuable information. I'm sure everyone is taking it in. And this is one of my favorite topics, having worked and formulated in the clean space. The lines have always been a little bit blurry. It always has been up to discretion of the brand of how to work with certain ingredients, claim certain pieces. So we have seen such a boom in the last, 5 years of these claims being, asked to be substantiated. What goes to say you're natural? What goes to say that you're clean? The Sephora, for instance, case that, just happened to come about in April, I mean, goes to show that there are people that are led to believe clean to be a certain definition versus a brand believing clean is a different definition. So I think you helped a lot of brands understand today how they should approach clean beauty, how they should represent themselves, and issues that they could potentially come across with legal and litigations because of those claims that they're making. And it is no surprise there are a lot of law firms and litigators out there that are attacking consumer beauty, up and down California, up and down East Coast. This is pulling things off the shelf and kind of hoping to catch somebody without the information that they have. So just want to say thank you, because your understanding and education on this is so important to protecting your brand, protecting your products, so that you don't end up in a situation where you don't have the right information. So let's get to some questions. We can start with one that I saw and grabbed immediately, but how can my company substantiate its claims? What is required? Is it by law that is required? Can you please elaborate?
Yeah, so under the FTC's guidelines, before a company can run an ad, it needs to have a reasonable basis for its claims. And the reasonable basis means objective evidence that supports the claim. So the kind of evidence really depends upon what the claim is, but at a minimum, an advertiser must have the level of evidence that it says that it has. So, for example, the statement 2 out of 3 doctors recommend X, Y, and Z pain reliever must be supported by reliable survey to that effect. And if the ad isn't specific, the FTC really looks at several factors to determine what level of proof is necessary. So, including what experts in the field think is needed to support that claim. And in most cases, ads that make health or safety claims must be supported by competent and reliable scientific evidence. So, tests, studies, and other scientific evidence that has been evaluated by people qualified to review it. So, in addition, any tests or studies must be conducted using methods that experts in the field accept as accurate. So it's very important to substantiate your claims, and generally following the guidelines of competent and reliable scientific evidence supporting those claims is a best practice.
And to have these tests and these support, do you recommend working and vetting out certain tests to make sure that they align with what you're looking to achieve? Because we know there's tons of testing places out there, right? So probably wise to make sure the testing protocols that you receive really do answer what you just outlined, right? That it's not a simplistic test to get a quick claim, so to say.
Right. No, it is important to do robust testing on the final product as it will be used by consumers, and important to have that competent, reliable scientific evidence that backs up any claims that are made in connection with the product.
Great. Another question, what makes an advertisement deceptive?
So yeah, and here the FTC really focuses on a test, and under the FTC's deception policy statement, an ad is deceptive if it contains a statement or omits information that is likely to mislead consumers acting reasonably under the circumstances. So the FTC and most courts throughout the country use this reasonable consumer test. What would a reasonable consumer think? And so when you have a claim such as clean, what does that mean to a reasonable consumer? And reasonable consumers have a wide variety of beliefs. And so, that's not we're not using an Albert Einstein level of, what he might think clean might mean. And so it's really important to make sure that you consider what these different claims are and how reasonable consumers will view them when they're making a purchase of that product and reviewing the label. Will they look at a label such as Nature Fusion, and will they see that term and think, oh, this must have only natural ingredients in this product? That's what courts will do. And there's a lot of case law about what a reasonable consumer is and how they perceive different labels. And so it's important to know the case law there, but it's also complicated because the case law is, it's tough to know exactly how one way a judge will rule when there's a case like the Pantene case that discusses Nature Fusion. And the court found that while the term's ambiguous, in that case, the court found that anybody who is concerned about it can clearly turn the product over, look at the back label, and see what's in the product, and see that there are synthetic ingredients in the product. And so they can not purchase that product. Whereas you have in the reef safe cases where there's, a reef safe claim that's being qualified with an asterisk, kind of guiding the consumer to the back of the label. In that case, the court found that no, that's not enough. Like, we don't know how to define reef safe, and consumers aren't chemists and they don't know exactly what exact ingredients might harm a reef. So it's really important to be very clear if you're making a claim such as reef safe or all natural, that you define, ideally on the front of the label what that means. Just like the Clean at Sephora program, when it said Clean at Sephora, it explained underneath what that meant. And so another factor for the FTC in the deception policy statement is that it's material. So it's important to a consumer's decision to buy or use the product. So that's
So,
really kind of how an advertisement might be deemed deceptive under the FTC and in the courts.
and I think you made a really good point that, consumers are not cosmetic chemists. They're not, regulatory compliance officers for cosmetics, but there's so much information out on the internet and social media and platforms that gives transparency into ingredients used in cosmetics that I think most consumers feel that they are somewhat cosmetic chemists, and have an understanding of how these ingredients work and how they work together. And I think that too fuels a lot of the discussions about what the consumer perceives, what the actual truth is, and how that displays out in market. I think is really kind of wrapping yourself around where we are in the beauty industry right now. I used to always joke as a regulatory professional, we were always forgotten about. We would make all these be careful, do this. And now in the last 5 to 10 years, it has really switched gears. What you say on a label, the regulatory reviews, all of that now is at the front of product development. It's at the front before you can do anything else in terms of formulation and selling and marketing. So it's very interesting to see how the beauty industry has shifted. And to jump off, just of your natural claims, there's a question that if my products comply with ISO 16128 standards for cosmetics defining natural ingredients, does that allow me to use a natural claim on my product and avoid litigation? So,
Yeah, so that's such a great question, and it's one that we've gotten a lot. The ISO standards set a different standard than what we have in the courts in the United States and what the United States regulations have for determining whether, say, like a natural claim is misleading or deceptive. So you can really follow the ISO standards until the cows come home, as my mom likes to say, but it's not going to make a difference in, and of course it matters for your brand and your product, but it's not going to make a difference in litigation, where the standard is really going to be the reasonable consumer standard and whether or not a natural claim might be misleading to a reasonable consumer. So there's been a lot of lawsuits filed against toothpaste companies and chapstick that claims to be all natural or natural, and it's unfortunate that these companies are following standards for what natural is but are still getting sued, and there's been some success in these lawsuits about whether or not it's misleading to say a product is natural if it does contain any preservatives or any synthetic ingredients. And so it's really a different standard in the United States and what we follow in the courts than the ISO standards. But yeah, it's you mentioned the trend of consumers believing that they're chemists and whatnot, and of course we're seeing so much influencer marketing and influencers just explaining how they interpret the science, and there's a lot of fear mongering that we're seeing in social media too, which is tough because companies are having to kind of combat that as well. And, it's important to really follow your cosmetic scientists and not these fear mongering influencers, discussing what it means to be natural and have natural beauty products and whatnot. It's a tough world out there for cosmetics companies right now.
and I think we have time for one more interesting discussion on animal testing. Question on raw materials, and since there may be transparency issues with suppliers from overseas, how deep should companies check on raw material levels on animal testing? So I think this is
a great question.
Yeah, this is a good one. So go ahead.
Yeah, no, with the John Paul Mitchell case, it's been a really interesting to see the way that plaintiffs' attorneys are going after this. And I think, with MOCRA, a lot of people were hoping that MOCRA, the federal government would ban animal testing in cosmetics nationwide. And the states are certainly doing a lot to fill in those regulatory gaps. But it's a tough issue because you want to make sure that if you have an animal cruelty free claim or a no animal testing claim, that you know that the history of that product, what were the ingredients in it. These class actions are really trying to get the class to go back to, I think, 2009, like it's several years back. And so it's very important to keep records of what ingredients have been used in your products, what are being used now, and to qualify those statements. What do you mean by animal free or animal testing free? What do you mean by cruelty free? And I know that certifications can help, but they're not enough to prevent lawsuits in this space. We've seen a lot of companies that do have the PETA and the cruelty-free certification, the Leaping Bunny, and they're still getting lawsuits filed against them for these products, particularly if they've been sold into the Chinese market is a big space where that's becoming an issue. And so these cases are being filed, consistently. So it's very important to be aware of that issue and to make sure that you have adequate record keeping and are able to substantiate that claim for a product line. It's also really tough to make that claim as a company as a whole. If you want to say let's say Christine Kruger Cosmetics company that I want to have, and I want to say my company has never tested on animals ever, we never will. You really have to be able to substantiate that with evidence and make sure that evidence goes back several years. And so it's a tough issue these days, but that's one area that we're seeing a lot of litigation.
Yeah, and I think there's also a misunderstanding between, the final product being tested on animals versus the raw materials used to make the final product as well. So going back to find the dates, if there was any animal testing done on a raw material, or to find those dates, because those too can help you substantiate those type of claims. But to never say it's ever been tested on animals is probably a very far stretch, especially since that was a very strong, the main way that most cosmetic products were tested. Raw materials used for cosmetic products were tested this way. There's substantial toxicological data on the testing of animals for a lot of ingredients in cosmetics. So you definitely want to do your due diligence, and if transparency issues, especially with suppliers overseas, always evaluate your suppliers and who you work with. It's very important that you have an open discussion, because you're liable for what you claim and what you receive from them. So to have a very transparent, open relationship is crucial with your suppliers. So that's always my best advice when we always hear, well, they're not giving me any information. And it's really, it's hard to hear that, because you should have an open relationship with your suppliers.
Absolutely.
Yeah. So I just want to thank you, Christine. This was so wonderful. I know so many people have taken away from this new information, and I'm sure we're going to have a ton of questions to follow up on. But just wanted to thank you again for your time and for your thoughtfulness and your just overall knowledge in this space. I think you are going to be very popular in the coming year, helping everyone trying to figure out the right way to word things and the right claims to make.
Okay, thank you so much. This is a lot of fun, and feel free to reach out if you have any questions. I love talking about clean beauty.
Thank you, everyone. Have a great day.
Thanks.